All right, we're back in Senate Judiciary. We have Ledge Counsel here to talk about H 645 and some changes that have been made.
Thank you, Vice Chair Hashim. For the record, my name is Ben Novogrodsky from the Office of Legislative Counsel, here to review draft 1.1 of a strike all amendment to H 645. There are two versions. 1.1 is a highlighted version for reader convenience. 1.2 is a clean version in case my work is impeccable and the committee wants to vote on it, but rarely is that the case.
The work is always impeccable. That's not the problem.
So turning to the bill, you'll see some added definitions to the definition section under 162A. The addition of criminal history records and criminal justice purposes under 20 VSA 2056A. This was included. There's a discussion I had with Attorney Leaders Dumont about, and this is about records deletion and when this is used, is that when you turn to that page on records deletion, which I should have readily available for you, but in my haste, I don't. So bear with me one moment while I, 60-page bill, it's really hard to keep the page numbers memorized. So I'm in the expungement portion, which this precedes. There we are. I believe confidentiality. And one of those, it is Friday, isn't it? It is. Yeah, thank you. So on page 16 would be the first instance of this that you'll see. So in the initial bill, within 30 days after the 2-year anniversary that notifies law enforcement and the state's attorneys of the participant's successful completion of the diversion program, the AG's office must provide a notice, no longer a certified notice, that all records held by the law enforcement agency in the state's attorney's office shall be deleted, including any held by the attorney general, sort of the belt and suspenders, that everything that could be deleted is deleted. And then what is exempted, though, are criminal history records maintained on the Valcor database or other similar non-public law enforcement databases are exempt from deletion and shall only be used for criminal justice purposes. And you may be asking, is that, page 16 is one instance of it in the juvenile portion. It's repeated identically in the adult portion. Yeah. So yeah, one may be asking, what is or what are criminal justice records? And those are all information documenting an individual's contact with the criminal justice system, including data regarding identification, arrest or citation, arraignment, judicial disposition, custody, and supervision. And criminal justice purposes means the investigation, apprehension, detention, adjudication, or correction of persons suspected, charged, or convicted of criminal offenses. They also include criminal identification activities and the collection, storage, and dissemination of criminal history records and screening for criminal justice employment. So that essentially ties the only information that can be retained is ones that could be used for those criminal justice purposes as defined under 2056A sub 3.
Is that what we currently do?
This is current practice. Okay. That's my understanding, and I would defer to Attorney Leaders Dumont on that.
Yeah, exactly. Yeah, exactly. I mean, if you think about, because we're talking about pre-charge, Tim Leaders Dumont from the Department of State Attorneys and Sheriffs. If we're talking about pre-charge, we're talking about something that there hasn't been a court filing yet, and so we're talking about, for example, myself and I always pick on myself and Senator Hashim go out and we're being disorderly outside, but it doesn't result in our arrest, maybe just their contact with law enforcement. And then let's say they did find probable cause in that circumstance and we're sent to go see Becky. In that circumstance, right, even though it wasn't a charge, there will be a record of that. And so the criminal justice purpose could be when maybe we both fail out of the CJC, when it does go, if it does go to an actual charge, they're taking that information that had been collected on that day to continue their investigation, so it doesn't get wiped off the face of the earth.
But it wouldn't be wiped off under this until you had completed.
That's correct, right. It would be deleted after completion. The issue would be the interaction itself would be deleted from not a case file, but basically a pre-charge information packet. Or it could be, it isn't necessarily an affidavit, it could be an email that law enforcement sends to me in the middle of the night, hey, here's what's going on, right? And that sort of information is important for criminal justice purposes, including, let's say that the person, we want to refer the person to CJC in the future. Okay, this person's been successful in the future, in the past, we want to refer them again because we know that they've been successful, that sort of thing. We don't want to delete the fact that they were successful from our records, so we know we can refer them again.
Okay, but that's sort of currently how it works. We're not making these records more porous or keeping things we don't keep now. Okay, thank you.
Right. And from a drafting perspective, I think one of it makes it a little bit more clear, since it's already a definition that's used, a practice that's in place. There's sort of, because when you read the prior language, public records do not include Valcor database or other similar non-public law enforcement databases. It's a little bit vaguer. And so this is more pointed.
Okay. Just want to make sure we weren't going backwards in well, in my view, backwards.
And in the way that this would work out, so this occurs within 30 days after the 2-year anniversary of the successful completion of diversion. So there is sort of that 2-year window that you kind of wait and see.
Yep.
Yeah.
Okay.
So going back to the beginning of the bill, so those are the 2 new definitions that are added and the specific provision that they involve. And then you'll see in the definition of pre-charge diversion on page 2, you'll see the addition of striking or and including and, so that the prosecutor, after the referring officer and the prosecutor has determined, so that would, there was discussion yesterday about ensuring that there's communication between the 2, and that it would be reasonable suspicion as opposed to probable cause. Yeah.
I think that's problematic. So reasonable suspicion to send someone, so law enforcement has to coordinate with the state's attorney to determine that reasonable suspicion exists to send somebody to a mandatory program, and
well,
if they don't, then they can get charged.
Well, so the program diversion's voluntary to begin with. That would be an option that if the individual chose to engage with, they would have that option if they had a referral. If it was denied or they were inappropriate, it would either go back to the law enforcement agency or the prosecutor. Probably in this case, and I can kind of go into what reasonable suspicion is a little bit for the committee's knowledge if you'd like.
I think though
but this is, I mean, from my perspective, is a little wonky.
Yeah.
And the reason why I say that is because reasonable suspicion is something that law enforcement typically engages in when you're stopping someone that you essentially suspect may or may be committing a crime. You know, so it's a lower threshold than probable cause. And so you're asking the law enforcement agent in the way that this is drafted to confer with the prosecutor about reasonable suspicion, which is something that they determine probably on a daily basis in their jobs.
Right, but so, I mean, actually, I'll just agree that I think it's wonky and perhaps we need to change it.
Well, so I agree, with Senator Hashim and you, Ben, that it's wonky. My concern with actually both making the and going to reasonable suspicion is, I think it creates a more burdensome system. No longer is it the officer set, because I know, like in Chittenden County, our state's attorney has a really great relationship with multiple different law enforcement organizations and sort of said to them, you can make the pretrial referral. And by saying and, that sort of eliminates that ability.
Exactly.
So I think it should be or. However, I also think it should be probable cause, because what we're talking about, I drew a little picture last time, but I don't have a whiteboard to put it up for everyone. What we're talking about is an alternative to a charge. And I need probable cause to make the charge. If I have now an alternative, I should need the same evidentiary standard to offer that alternative. Like, it shouldn't be a different evidentiary standard. And I think it creates all kinds of problems in that it's offered. So we say, okay, you can do diversion or there's a charge, except actually I don't have the evidence for the charge. And so I think it creates a bunch of wonkiness, lowering that standard in this one space. And if there's only reasonable suspicion, my understanding, and certainly correct me if I'm wrong, is that a community referral could still be made. So that person could still be referred.
Yeah, I think it would blur that line of where community referral ends and, a referral under this would begin. I think it would make it harder to make that distinction.
I agree, which is why I would advocate that we stick with the original language of or and probable cause.
Can I ask for, you said that you could go into reasonable suspicion a little bit. Could you just give a case, a made-up case, where an officer, let's say, has reasonable suspicion and then without a prosecutor refers to diversion?
Right. So the way this is like, the ready example I have is like, let's say in a traffic stop, right? And that's typically where a lot of the case law is about, the investigative stops are also called Terry stops, if that rings a bell as well, after the Terry v. Ohio, or the Terry case. But it's justified, so reasonable suspicion is justified if the officer has a reasonable and articulable suspicion of criminal activity, and it requires less proof of wrongdoing, by preponderance of the evidence, and it's assessed by examining the totality of the circumstances, and you're balancing the public's interest in safety against the relatively minimal intrusion posed by a brief investigative detention. So basically what it does is that if someone is charged and in the interaction, or not charged, someone is stopped and the police officer smells alcohol on their breath, that would potentially provide them with reasonable suspicion to do further investigation of the individual. So, okay, I want you to step out of the car now. Let's do some field sobriety testing, because that is more of an intrusion on their Fourth Amendment rights and their privacy rights. And so when you have that piece of evidence, it can create a level of reasonable suspicion that legally permits them to investigate further.
Okay, and so just to follow up, so in that instance, you're not going to say, I have reasonable suspicion that you've been drinking, but I'm not going to charge you, I'm going to divert you.
Right.
So give me an example where you would actually divert somebody without charging. Because that's what this does.
Right. And I might defer to my colleagues here about situations that maybe they've encountered where, and again, I think this is where it blurs a line with community referrals, where maybe there's sort of a fight in school, right?
Yeah.
And kids in school, they're 16, 17 years old. They're boys will be boys, if you will. And rather than really bringing them through the whole criminal process, maybe there's a school resource officer there that identifies and says, maybe this could be charged, but it's really just like kind of a smaller dispute. Let's have them resolve it through a restorative process rather than charging them.
Yeah.
And going through that way. So that's where I think a situation where it blurs that line between something that really doesn't rise to the level of a crime, but obviously has some sort of conflict. And so this would be diverting them to the pre-charge diversion process, or have the potential to anytime a conflict arises that wouldn't be chargeable.
Okay, and then the last thing I'll ask is, in that example, what would be the difference between probable cause and reasonable suspicion?
So probable cause, I think, more objectively, you really need evidence that a crime has been committed, as opposed to just sort of some suspicion based on some facts that you've seen that there's reason for more investigation. So it's sort of that basis for further investigation compared to really objective standards to show a crime has been committed from the officer's perspective. So it's that higher standard. And Tim, kind of, if you think I'm off base, so.
No, I think about it like a spectrum. I mean, reasonable suspicion sometimes merges into probable cause,
Mhm.
and so it's lower than probable cause. And an example that arose in a county that will remain nameless at the moment because it has to do with young folks. But there was an argument about probable cause at an arraignment, where at every arraignment, the defense attorney can challenge probable cause. And there was an argument, and at that point, actually technically before the person was arraigned, the individual and the state's attorney said, let's send them to the CJC because there is this issue about probable cause potentially not being met here. And they didn't want to litigate it and extend it. So it's sent to the CJC. In that situation, technically, a judge didn't find probable cause. Law enforcement officer did, state's attorney did, judge didn't find it because they didn't get to that point. And they resolved it very fluidly by sending it to the CJC.
Yeah, and I get that. I'm just wondering if we're moving from probable cause to a lower standard, are we allowing too much authority to the referring officer? That's my only
If we
question.
move from probable cause to reasonable suspicion,
It just casts a wider net, and by having it be probable cause, there's nothing that stops that officer from referring under a community referral. It just doesn't enter the pre-charge system and become more formalized within the criminal system. So I think we're widening the net of who comes into, sure, a lower level of the criminal system, but still the criminal system.
so,
Yeah.
I mean, I guess maybe a question for the committee, but this specific section, this definition that we have for pre-charge diversion, I mean, what is that specific definition trying to address, and why do we need it, or do we even need the entire thing?
So the testimony from the state's attorneys, and I think also from the CJCs themselves, have indicated, there's a concern that various state's attorneys have had that, they want to make sure that this is going to be worthwhile, that there's going to be enough evidence to go through this process, but yet maintains flexibility. So that's why you'll see later why the contents are written, of the policies are written the way they are, is to provide the state's attorneys that flexibility to do what they want. But, and also for the CJCs, they've expressed concerns specifically about, well, how does this affect our current operation when it comes to those community referrals? And so this was really done to try and keep those community referrals out of the equation, and also make sure that the incident itself is serious enough to warrant this process.
Could we put language in then, let's say if we have it back to probable cause, and we say referring officer or prosecutor, and then an additional sentence that says, nothing in this definition will prohibit cases being sent to community justice centers, to provide more clarity for CJCs so that they're not.
As far as what though? As far as, community
Anything that
referrals?
is below probable cause for a community referral.
Yeah, I think that could be written in. Yeah.
Would that be helpful, actually? Would that be helpful?
Becky, maybe speak to
So-
that.
For the record, Becky Penberthy, I work at the Burlington Community Justice Center. So would that be helpful? I think it creates another category, like maybe perhaps a bigger category. I do appreciate the category because in terms of like what Senator Bayowski was saying with net widening, I think about youth mostly. Like we widen nets to catch youth a lot. And so if there's the fight in the school and it's more of a school-based conflict, I like the community school referral piece. I less like the pre-charge piece because the more we bring youth into the system, the more likely we are to keep them there. So dealing with it, even having a different name is really impactful. I don't, does the bill sort of allow for like another tier to be in there? The community referrals are in there, but does it allow for this to be sort of widened per se?
I might just add some like context. I think community referrals, any law enforcement officer, regardless of this bill now or in the future, can send a matter, can suggest that something go to the CJC, and that would be a community referral. Likewise, if an officer's like, hey, I didn't find PC, but I'm calling you, Tim, because I don't know what to do, I would also say that feels kind of like a community referral, or we often say is more like a direct referral. So you could say that anything that's not a pre-charge referral in this bill may be considered a community referral that may also be accepted under the discretion of the CJCs to accept it or not.
Just to follow up and then Senator Norris, but so if we were to put language in that says nothing in this definition will prohibit sending cases at the officer's discretion to community justice centers like the school fight, would that be, would that get at your concern that, like the two kids fighting can still go to a CJC instead of going into pre-charge diversion?
I think speaking personally from my experience, that would resolve my concern about that. The rub could be that, the group of youth say, no, we don't want to work with the CJC, and then what? Because they could absolutely opt out, where hopefully with pre-charge, there would absolutely be a charge if for some reason we return that case.
But under reasonable suspicion, there
Senator,
would,
sorry.
oh, sorry.
Senator Norris?
So, a couple of things. My very basic description of reasonable suspicion versus probable cause is you're following a car down the road. The operator bumps the yellow line 2 or 3 times. Immediately people say, oh, he or she's intoxicated. You've already established what's referred to as reasonable suspicion to believe that something may be wrong with the operator in that car. Not that he or she has been drinking. You pull them over, start talking to them, slurred speech, bloody eyes, smell of alcohol, you get them up to the next stairs. Now you're establishing what's referred to as probable cause. Right. In the referral system here, I like the reasonable suspicion, and the reason that I do is because it leaves out the possibility of putting the youth into the juvenile system. It could be as simple as a phone call, or quite simply an officer's report to the state attorney's office saying this is what's going on. Before I go any further, establishing further probable cause, because if you go to all that bother to do the paperwork, establish your probable cause and send it over, there may be some folks that say, I'm not going to bother making any referrals because I've gone through all this work of establishing the affidavits and so on and so forth. So I like the idea of not putting these young people into the juvenile system here, rather than just make a referral. That's what it is. It doesn't say you have to go, as she stated, but it's just a referral. And it could be based just off the officer's report, in my opinion only.
Senator Norris? Pahoski, sorry.
So my understanding of the situation, if there was reasonable, so 2 things. 1, if it's reasonable suspicion, there might not be a charge. So you might say, I have reasonable suspicion, you have to do pre-charge, and then maybe I'll have enough for a charge. So there isn't that same level, because it doesn't meet the same evidentiary standard of being able to charge. Whereas if I have reasonable suspicion, and we can add the language here, there's nothing to prevent me from just making a direct community referral. And if I did establish probable cause and I'm thinking there's a charge, the state's attorney could still decide, actually, I want to refer that. So there's multiple mechanisms here. And for me, it's simpler and the alignment makes more sense for pre-charge to have the same evidentiary standard regardless of what path it's going to take. And the community referrals be what happens if we haven't met the evidentiary standard. Because I actually don't have the charge to hold over someone's head if all I've met is reasonable suspicion.
And if I might, I agree. And what I would add to it is, I find myself going back to the custodial interrogation discussion and the way that people of a younger age will go along with law enforcement if law enforcement is leading them in a certain direction, even if it isn't the truth. They want to go along because they feel like they're adopting a simpler path to escape by going along with the authority figure. And so what I'm wondering about is, if it's reasonable suspicion and it's one referring officer, and that person says to them, you have the choice to go into the diversion or not. It's your choice, but I'm gonna find probable cause and prosecute you if you don't. I just worry that some of these juveniles will go along with it anyway, even if. So I guess what I'm questioning is having the whole thing subsist on a suspicion, even if it's reasonable, and that's the only thing that the system has to compel the person. I'm more comfortable with, I think the bill's original language was probable cause. cause, right?
Yeah, it was or,
Yeah,
officer
yeah,
or.
I am more comfortable with that for that reason, just because I feel like you could wind up having, I mean, I think there are a lot of kids, if you tell them, you can go into this diversion program or we can prosecute you, they're gonna pick the diversion program because they're not sophisticated enough to know reasonable suspicion versus probable cause, what their odds are. Maybe they don't have money for lawyers, so they're like, okay, I'm caught even though I didn't really do it, I'm gonna go on.
Don't you think their parents would be involved in this, or their guardian or something, or rather
Well-
leaving that onus on the kid to make that decision?
Same with the custodial interrogation, you know?
I'm just trying to keep them out of court, that's all I'm trying to do.
Yeah,
Well, and if I may, Senator Sheen, you know, a really helpful explanation of this reasonable, it really elucidated it for me, is that the reasonable suspicion standard is not high. Certainly, it is less demanding than probable cause, requiring only facts sufficient to give rise to a reasonable suspicion that criminal activity may be afoot. And it continues, thus, conduct that is as consistent with innocence as with guilt may form the basis for an investigative stop where there is some indication of possible illicit activity. And I think Senator Norris's example is exactly that. You can see someone swerve, and there could be a bunch of reasons for that. Maybe they just were distracted momentarily. Maybe they're drunk. And so reasonable suspicion would potentially, in this realm, might bring someone that was doing something that was otherwise innocent.
but again, in that instance, somebody bumps the yellow line a couple of times. We would find it odd if you went up to them and said, look, you can pick diversion.
Right.
Or we can, you know, they'd be like, what? But we're gonna do that, I feel like with people, if we make this language change, we're not gonna be finding probable cause, but we're gonna be giving them the option to enter, if not the system, a system.
Right.
But just to expound upon that, using your example.
Yeah, yeah.
Bumping the yellow line is not a crime. Where it states here, it says reasonable suspicion exists that an individual has committed a criminal offense. Bumping the yellow line is not a criminal offense.
Well, no,
So I'm
but,
not gonna offer him
but you're saying,
the diversion
you're
versus.
saying it's reasonable suspicion of a crime, which is driving.
No, it's reasonable suspicion there may be something awry in the car. It could be they're lacking medication, they're tired, they dropped their cell phone, at least but not last, maybe they're intoxicated. I don't know that, but something's wrong, so I'm gonna pull over and say, hey, you all right?
I will say that language you read about there are as many indications that it's innocent behavior as guilty does not give me a lot of confidence.
Right, no, I mean, it's really, I think, a good explanation of it. And the other thing too, I mean, it's not like this community referral aspect is completely untouched in this bill. In section 9, so pages 59 to 60, all the way at the end almost, it talks about a report that the AG's office has to submit specifically on community referrals. And it does have a definition, at least for this purpose, that it's referrals to community-based restorative justice providers that do not involve criminal offenses for which probable cause has been established. So there's, and this goes back to my initial testimony, which is this bill doesn't do everything. It does some things, and it sets in motion some initiatives to address broader issues, funding, community referrals, things of that nature. So it's not a silver bullet for all these issues now, but it does address some and sets in motion others.
I think it just makes more sense to me here to stick with probable cause, but to add language that makes it quite clear that community and direct referrals can happen regardless of probable cause. I don't know, actually, Attorney Leaders Dumont worded it in a way that made a lot of sense to me, but I also imagine you could figure out.
Would you want to use the language that was defined later in the bill?
Is it already in the bill?
Yeah, so,
Oh, well, perfect.
page 60, not, you know, it's limited to that section, but it could be used, in this section. Subsection B on that page.
Yeah, I think that's fine. Just sort of repeating it here that nothing in this definition means that that can't happen.
Right. Oh, I mean, I could add that as a definition,
Oh, okay.
and then just refer to it in this portion.
Tim?
I just wanted to say that the robust discussion you're having today highlights why we will need we do not have a community justice unit. Our department effectively trains law enforcement about how to react in the field. And if you want this to be successful, and I know I said it yesterday, I just want to stress again, our department needs a full-time position to effectively assist with not just the publication of the policies, which I wanted to say on the record, we had a meeting with all the state's attorneys, and they are all working on chatting with their local CJCs, those that don't have policies that are written. A lot of them actually had draft policies that I wasn't aware of.
Mhm.
So we're hoping to publish those on our website in the next couple of weeks when they become more formalized. And I'm actually working with the state attorneys now on that. So that is something that they're going to require constant editing. They're not, stagnant documents. But in terms of the next step, training law enforcement, here's what this referral looks like. Here's what this referral looks like. Here's what this policy is going to be. For it to go smoothly and not be something that falls to the wind. Representative Arsenault said, flower the plants that you want to grow. So if you want this plant to grow, you need to fund it with a position.
So
Can I
I,
say flower them?
Water the plant. It's April.
So can I ask Tim, I appreciate the follow-up work on the policies and the fact that they have drafts. Am I understanding you right, that you would no longer oppose requiring a policy?
I think that what I
Because
told them is,
if we go out of session and then we have 2 or 3 who somehow don't get it together, then we're out of luck.
I think probably what I told them is, it's only going to assist you all, John Campbell, it's only going to assist you all if you have a policy.
Mm-hmm.
And so all of them were very open to it. There was even a couple where I was maybe unsure if they would be interested in pre-charge, and they said, oh yeah, we're actually talking about it right now, CJCs. I think having a policy maybe within, not having a drop like on July 1st, I doubt they'll all be ready by July 1st, given the other stresses on our department, but having a policy at some point over the next 6 months or so, I think is reasonable for sure.
Great, that helps. Thank you.
I think given the time, we can move on to the next section unless there's anything else.
Okay, so moving on to page 3, again, you'll see sort of the change to reasonable suspicion. I'll now just put that back to how it was.
With the additional language too.
No, I mean, I think what it would do is to just input, probable cause instead of reasonable suspicion. Because what this language does is to say that, any crime that has probable cause against a juvenile would be eligible for the pre-charge program. So I know that was a discussion point to ensure that it was explicit that, all juveniles would be potentially eligible.
Oh, is this to be consistent with what you mentioned on page 60? Or?
No, so this is sort of in relation to later on where the policy requirements included a presumptive list of offenses. That's been struck, and to sort of belt and suspenders it, explicit language has been added here to ensure that any offenses against a juvenile would be potentially eligible.
Okay.
So I'll just replace probable reasonable suspicion with probable cause. Then you'll see on page 4, striking the language that the AG may require local contributions, and then inserting language that the program may only operate to the extent funds are appropriated to the AG's office, the Department of State's attorneys, and the Office of the Attorney Defender General, to carry out the program. Any questions on that language? Then going forward onto page 7, you'll see now that at the bottom of the page, lines 18 through 20, it strikes the introductory language that in order for a county's community-based restorative justice provider to be eligible to receive pre-charge referrals, so no longer has that hook, and now only requires that the policy be adopted, but essentially there's no consequence if it's not outside of being out of compliance with the law.
Thank you.
And then on the next page, page 8, this was the language that I referenced a bit earlier, that the list of presumptive offenses have been struck, and just some grammatical changes to the remaining, saying that criteria to determine whether a child or youth is eligible, must be in the policy, and any appropriate documentation. So that changes it, that if there are certain state's attorneys that don't want any appropriate documentation to carry out this process, they have the discretion to do that. But if they do, it has to include this minimum information. And these changes are also reflected in the adult portion, I believe. So if you turn to page 15, and we've kind of briefly gone over this already, striking the certified notice language, so it now is just a notice that's sent, and then going into the records and criminal history records and purposes that I've already reviewed. And then finally, I believe that the only other changes that are not the same in the adult section are the ones to the reporting requirements at the end of the bill on page 59. That you'll now, Willa Farrell had recommended that the Attorney General's office wanted to bump up the reporting date from July 1st, 2027, on the report for their diversion administration plan. So this is really about kind of funding structures and operations that they have to confer with the providers and the county state's attorney to develop a plan to streamline the administration and provision of the pre-charge and post-charge program. So that can include financial stability, things of that nature. So bumping that up from July 1st, 2027 to April 1st, 2025, and sending it to Senate and House Committees on Judiciary by the same date. And then finally, one final change on line 11 on page 59, that the Attorney General may offer to grant. It's not a mandate anymore, and that was a point of discussion.
Mr. Vice Chair, I'm wondering if government operations has an interest in looking at this. There's whether things trigger open records stuff in here. Senator Husky, do you?
I mean, I don't want to speak for the whole committee, but there's nothing in here that is explicitly making me think it would need to go to
Okay.
GovOps. And I mean, if we want to add them, we want to add them. There's nothing stopping Senate GovOps from looking at the report if we are concerned.
And Senator Ruth, there is a public records exception worked into this bill for information that's disclosed during the diversion.
That's what I mean.
Yeah.
So
The public records aspect.
Yeah.
those are generally things that GovOps looks at, signs off on. So
I'm happy to run it by the chair.
if you could.
And we
Like
can,
a drive-through of any, is that sort of? what
well,
you're
I'll
doing?
just connect.
Yeah.
Let's not propose drive-bys.
Friday, I'm sorry.
I like drive-through, maybe you get a drink.
Right, exactly. So, no
I'll
pressure
check with the
experience.
chair, and
Yeah.
if we need to add it, I'll
I'm
let
just-
Ben know.
I would hate to
Yeah.
have Senator Hardy stand up on the floor and say, you're into public records here.
I'll ask.
Maybe I'll bring drinks.
Yeah.
I would welcome that.
Try.
But they must be decanted.
Yes. For the trust decanting act,
Yes.
yeah.
I think there's one other change too, on page 60. The redesignation.
Oh, yes. Sorry, in the grand scheme of things,
Yes.
it's kind of low on my list.
Yes.
And then the redesignation of the statutes have been struck, so they'll remain in Title 24.
Good cut.
Thank you, Senator Bielski, for that reminder on Friday.
Yes. The only thing that stands out to me, and it's not something that is gonna stop me from supporting the bill, but I don't love that there is no hook to sort of ensure that the policies are in place for people that are gonna be doing pre-charge work. Like I know that Senator Sears sees it as a punishment to the CJCs. I don't see it that way. I see it really as like ensuring that if this work is being done, it's being done transparently and out in the open. And like, I actually feel somewhat strongly that if there is no policy for how this work is being done, it shouldn't be being done.
Well, we have in the past conditioned law enforcement agency grants.
But that's what it previously did, and now it doesn't.
Well, but they were going to CJC. What we've done before is when people weren't reporting roadside data, then we said, unless you report the roadside stop data, you can't get state grants for your law enforcement agency. And that was by and large successful, I think. So that is kind of a precedent for what you're talking about, where we could say, unless you're publishing a policy, you're not eligible for law enforcement grants.
Well, I don't know that so is your suggestion to put language that will prohibit law enforcement grants if the state's attorneys do not publish their policies?
Well, I'm just suggesting that we attach the penalty to the people who are refusing to do the work. So in that case, it was the law enforcement agency. Is there a way that we can require the state's attorney and condition something that we?
Do we have a reason to think, though, that they're not going to publish their policies?
I wonder why they don't have them published already, those that have them. But maybe we could wait and see if they don't, we could always come back.
Yeah, I don't think there's any, because I'm seeing, on line 18 on page 7, it's juvenile pre-charge diversion policy required, and they'll adopt the policy, and they'll publish the policy.
Yeah.
I guess what I'm saying is we had the same requirement for roadside stop data, and then agencies just didn't report it. They just ignored the law. And then that left us in a situation where we had to do something, and so there was suddenly a stick introduced. But I guess I'm not saying we need a stick in this bill. I think we could count on what Tim is saying as a willingness to go down that path.
Yeah, no, I hear that, and I fully believe that the state's attorneys intend to and will do as they said they've done. I guess my concern, I can see how it is viewed as a stick. I don't view it as a stick so much as saying, what I view this as is what, I'm trying to think of how I want to word this. I like I said, I know Senator Sears viewed the language on 18, 19, and 20 as a stick or a punishment. What I sort of view it as is a belief that if there isn't a policy, this work shouldn't be being done, therefore we're not funding it. And I fully think that the state's attorneys will do it and the CJCs will do it. And so this is why this is not the hill I'm gonna die on. But it sort of, for me, doesn't feel like so much of a stick or a punishment as it does just like a belief that the policy should exist before the work is funded.
Senator, I might add one thing if I may. In Lamoille, I was talking with the Lamoille interim state's attorney yesterday, and she said, I can publish something tonight, but I want to work with my CJC to make sure that they're good with what I'm going to publish, which I thought was a really encouraging comment. And that's one of the 3 counties where they don't really have one. And so I just wanted to illustrate that that's some of the thinking that's gone on after the meeting with the state's attorneys. Thanks for the heads up, Tim and John. We're going to work with our CDC to make sure whatever we're publishing, they're good with too, which is good. And I think it's probably a reflection of, looking to Chittenden County folks, how they back and forth with the state's attorney and the providers.
I want to adjourn in about 2 minutes so that we have a couple minutes before the floor, but are there any closing remarks from any other folks? Like you guys, anything that you want to mention or before we adjourn? You don't have to, but just wanted to give you the opportunity.
Lauren Yondel, Attorney General's office. I'm here filling in for Willa Farrell, who's out today. It seems like everything that's been discussed is very consistent with the feedback that Willa provided to me. So I appreciate your thoughtful work in this matter.
Thank you.
Yeah, I don't think I have any final thoughts, but thanks so much for asking.
I actually have a question for Becky that hopefully will help the bill. I would want to make sure the CJCs can communicate with each other and any other state's attorney concerning any participant. The way I read the confidentiality provisions, I just want to make sure that she wouldn't be prohibited from calling another CJC about a participant to see whether or not they might be successful. And I would want to make sure that you could. Because you testified a couple of weeks ago now about, the communication between providers might be an important thing for other states.
If I may, Becky Pemberty. Currently within the system now, we have post-charge diversion sort of isolated over here and pre-charge, which is, it's very unwieldy. And if there is, if I get a referral for a person, for diversion, I can look them up in Odyssey and I can understand what's happening for them across the state. And if they're working with someone in Addison County, I can call up the CJC in Addison County and say, hey, so-and-so just got referred to diversion. One, is it an appropriate referral? Should they get this referral? Because I see that they're in your program too. And do you want to take them? Like, we need to consolidate these cases because I can tell you that frequently I get a person in either pre or post-charge diversion and they're like, oh yeah, I'm working with so-and-so over here. And, I'm in Chittenden County, so you could have one person working with 3 CJCs in Chittenden County alone and maybe somebody in Addison at this point.
Okay.
Go
Sorry.
ahead.
I was just gonna, Ben, if you don't mind making a note, we're planning to talk about this again and likely vote next week. So we can make a note to, talk about that for a few minutes or.
Yeah, and just one question on that point, is the concern not only speaking between different providers, but also providers that might be handling a post-charge diversion case and ones that had handled a pre-charge case for the same individual?
I think if all these cases were under the Attorney General's office, then we would be able to communicate.
Yeah.
Like, I can communicate freely with the other diversion directors, but I cannot communicate freely with the other pre-charge directors.
Right. So but I guess my question is, does it involve, and we can talk about this on offline too.
Yeah.
I'm just
Yeah, we
gonna
can- we're gonna-
circle up with
yeah.